Hypothetical for you, if a gay man who's a realtor asked you to design a website for his business, are you taking that job?
Of course, and it's not a hypothetical. I have clients who identify as LGBT. I work with clients from all walks of life. I cannot create every message requested of me.
You do a great job. This is hypothetical number 2, and then I'll get off the hypotheticals at least for now. You do a great job for a man and woman getting married. A same-sex couple see the website you create and they say, we want exactly that. Just change the pictures and change the date. Don't do anything else. Give us what you gave them. How about that?
I don't specialize in that type of speech. Everything I create is unique and one of a kind. Again, I'm always looking at the message that I'm being asked to create. What I think is really important to emphasize here is that for the last 7 years, the state of Colorado has been silencing and coercing my speech and forcing me to create a message I don't wish to create. Nobody should be put in that position, and the court's decision yesterday protects speech not just for me, for the LGBT website designer and every other artist out there. Nobody should be punished by the government for speaking consistent with their beliefs.
Counselor, I see you shaking your head. Let me ask you a question. I read the opinion last night. By the way, it's great reading, both the majority and the minority view, and I recommend the dissenting view, and I recommend that Americans who are interested in this take the time to do so. It's written mostly in plain speak. I thought before I read it that this was going to be largely predicated on Lorie's religious beliefs, and that is not my takeaway. Instead, it's about her speech, but it makes me wonder, okay, what about someone who's just uncomfortable with whatever might be the client in front of them having nothing to do with faith? Doesn't that open the door for animus to be a determinant?
The court's decision does not do that at all. It reaffirmed a time-honored principle found in our Constitution, which is that the First Amendment follows a golden rule. If we want to protect speech for ourselves, then we need to protect it for others, even those we disagree with. Whether someone feels uncomfortable, they certainly can't deny service because they feel uncomfortable. The court's ruling says that non-discrimination laws continue to apply to ensure that people can't be denied services or goods because of a protected characteristic. But it also says that no matter who you are, the government can't force you to say something that you don't believe. And that's a win for everyone.
Right. You make it sound as if these are black and white determinations, though. I think a lot of this is in the gray area. What exactly is speech? I don't know why so much of this litigation is in a wedding context, but okay, I'll roll with it. So I guess the baker is speaking. I guess the website designer, your client, is speaking. Presumably the florist is speaking, the photographer. What about the stagehand? What about the wedding singer? What about all those ancillary businesses that go into it? Are they all offering speech, or aren't they just there doing a job like they would do for any other couple?
If they're doing a job and there's not speech involved, then the non-discrimination principles apply, and the First Amendment does not in the free speech context. And so I think you're overcomplicating it. As you open, the court's decision, the majority decision by Justice Gorsuch is clear. There are clear tests in the law as to when speech is involved. We know when speech is involved. And here we have the written, printed word. So there's no question that speech is involved. In terms of Justice Sotomayor's dissent, as the majority said, she's litigating a case that wasn't even before the court and on entirely different facts. So again, like you said, Americans should read the decision and decide for themselves.
Okay, I'm in my hypothetical, counselor, I'm an atheist, and I'm in one of these ancillary businesses. And when couples get together in a non-religious environment or ceremony, I'm going to provide my services. But wait a minute, this is a religious wedding. I don't want a part of that. Is that okay?
Well, I'm not sure what your atheist is doing. And so what matters is, are they being asked to...
I'm a florist, I'm a photographer, I'm a web designer, or I'm a baker. But I'm an atheist, and I'm only going to provide these services for fellow atheists, even though I hold myself out to the public.
It's about what the speech is that's being requested. Lorie has always made distinctions based on what the message is that she's being asked to give voice to, and that's a critical distinction that the court reaffirmed. The test has always been whether the speaker's message is affected by what the government wants them to say. And that's the test that will continue to apply. The court didn't create new law. They just applied it in a cultural moment where some disagree with Lorie's message. And it's important that we stick to protecting freedom, because political and cultural winds shift. And if the government can compel Lorie, it can compel the LGBT website designer as well. We all need to remember that.
This is a law school dream, this case. Lorie, a final one for you. Think of the pharmacist called upon to fill a prescription for birth control who has a religious objection to doing so. I would say, hey, you chose to be a pharmacist, and if you have trouble providing this service, maybe this is not a gig for you. What about someone who similarly says, if you want to be a web designer, you got to serve everybody, and your religion can't come into it? You get the final word.
My final word is this: I create speech for a living. When speech is involved, speech should be protected. This protects not just me, the LGBT website designer, the Jewish calligrapher, the Democrat speechwriter, the pro-life photographer. We all benefit from the court's ruling yesterday.